I watched a colleague sign a severance agreement without reading it carefully because the HR director was sitting across the table with a pen, creating pressure to execute the document immediately. That signature cost her $47,000 in unvested stock options she didn't realize she was forfeiting. And it waived her right to challenge a termination that was, in my professional assessment after reviewing the circumstances, almost certainly age discrimination. She was 53 years old. She had no idea what she was signing away. I'm Elle, and I spent 32 years practicing law, and I'm going to teach you exactly what companies hope you don't understand about severance negotiations after 50, because what you don't know can cost you tens of thousands of dollars and eliminate legal protections you may desperately need. If you've been handed a severance packet, or if you're facing termination and expect one is coming, the next 20 minutes could be the most valuable investment you make in protecting your financial future. Let's begin. What severance actually is and isn't. The fundamental misunderstanding. Most people think severance represents the company's generous final gesture, a parting gift, acknowledging years of service and wishing you well as you transition to whatever comes next. That's not what severance is. Severance is a transaction. You're selling something of considerable value, your legal rights, your ability to challenge the termination, potentially your freedom to work for competitors. And the company is purchasing your silence, your cooperation, and your agreement not to pursue claims against them. This transaction reality changes everything about how you should approach the negotiation, because once you understand you're selling something valuable, you can evaluate whether the price they're offering represents fair compensation for what you're relinquishing, what you're already entitled to receive. Before we discuss what constitutes legitimate severance consideration, you need to understand with absolute clarity what the company already owes you, regardless of whether you sign any agreement whatsoever. Your final paycheck, covering all hours worked through your termination date, belongs to you. The payout for accrued vacation time that you earned through your employment belongs to you. In most states, this is legally mandated compensation, not a discretionary benefit. Sick leave payout, if your state requires it, belongs to you. Pending business expense reimbursements for business expenses you incurred on the company's behalf belong to you. Any commissions or bonuses you earned based on performance completed before your termination date belong to you. Companies sometimes present severance packages that bundle these mandatory payments together with additional consideration, creating the impression that they're offering more than they actually are. You need to separate what you're owed by law from what represents genuine additional compensation in exchange for signing away your rights. Legitimate severance consideration includes compensation beyond what you've already earned, additional weeks or months of continued salary, extended health insurance coverage beyond the minimum COBRA notification period, outplacement services providing professional job search support, continuation of certain benefits, potentially accelerated vesting of stock options or retirement contributions, written letters of reference or agreements about how the company will characterize your departure to future employers. These elements represent value beyond your earned compensation, which means they can serve as legitimate consideration in exchange for the rights you're waiving through the severance agreement. The critical question you need to ask is what they're offering worth what I'm giving up? That's the entire negotiation in one sentence. Your legal protections under federal law, the Older Workers Benefit Protection Act. If you're over 40 years old, which encompasses most of the professionals watching this video, you're protected by specific federal legislation called the Older Workers Benefit Protection Act, typically abbreviated as OWBPA. This law was enacted specifically because Congress recognized that older workers were being pressured into signing away age discrimination claims without adequate time to consider what they were relinquishing or access to legal counsel who could advise them properly. The OWBPA establishes minimum requirements that any severance agreement must meet if it includes a waiver of your right to file age discrimination claims under the Age Discrimination in Employment Act. If the company fails to comply with even one of these requirements, the waiver becomes legally invalid, which means you retain the right to discrimination claims even after signing the agreement. Understanding these protections gives you significant leverage because the company needs a valid waiver to protect themselves from future legal liability. The mandatory elements are, first, the agreement must be written in clear, straightforward language, not buried in complex legal sentences designed to obscure meaning, not filled with technical jargon that requires specialized expertise to decipher. The language must be accessible to someone without legal training, and the terms must be presented in ways that don't mislead you about what you're signing or what rights you're waiving. If you're reading the severance agreement and struggling to understand what specific provisions mean, that's a red flag suggesting the document may not meet the clarity requirements the law mandates. Second, the agreement must explicitly reference the Age Discrimination in Employment Act. The waiver must make clear that you're specifically releasing potential claims under ADEA, not just vaguely waiving any and all claims without identifying what legal protections you're surrendering. This requirement exists so you understand precisely what you're giving up. Third, you must receive written advisement to consult with an attorney before signing. This isn't merely a courteous suggestion the company extends if they're feeling generous. It's a mandatory provision required for the waiver to be legally valid. The agreement must explicitly tell you that you should seek legal counsel, and companies cannot pressure you to forego that consultation or suggest that doing so represents a lack of good faith on your part. Fourth, you're entitled to at least 21 days to consider the offer, not 24 hours, not we need your decision by the end of the week. A minimum of 21 calendar days from the date they present the agreement to you. And if they make any material changes to the terms during that consideration period, if they modify compensation amounts, alter restrictive covenants, change the scope of what you're waiving, the 21-day clock resets completely and you get another 21 days starting from the date of the modification. This extended timeline exists specifically so you can review the document carefully, consult with an attorney, consider your options without artificial time pressure, and make a genuinely informed decision rather than signing under duress. Fifth, you retain a 7-day revocation period after signing. Even after you've signed the agreement, you have 7 calendar days during which you can change your mind and withdraw your acceptance. This cooling off period protects against decisions made under immediate emotional distress or undue pressure, giving you one final opportunity to reconsider before the waiver becomes binding. Sixth, your signature must represent knowing and voluntary consent. The company cannot coerce you, threaten you with adverse consequences if you refuse to sign, or create artificial urgency suggesting you must execute the agreement immediately or lose the opportunity entirely. Your decision must be genuinely voluntary, made with full understanding of what you're agreeing to. If any of these protections are violated, if they rush you, if the language is deliberately obscure, if they fail to reference the ADEA explicitly, if they don't provide adequate consideration time, the waiver fails. And a failed waiver means you retain all your legal rights despite having signed the document. There are special rules for group terminations. If you're being terminated as part of a group reduction in force, meaning 2 or more employees over 40 are being let go as part of the same decision-making process, or exit incentive program, even if the actual termination dates don't occur simultaneously, additional protections apply. Your consideration period extends from 21 to 45 days, giving you substantially more time to evaluate the offer and consult with advisors. Additionally, the company must provide you with specific information about the group termination, the job titles and the ages of all employees being terminated, the ages of employees in the same job classification or organizational unit who are being retained, and the eligibility factors or selection criteria used in determining who gets terminated and who stays. This disclosure requirement exists so you can evaluate whether age discrimination might be operating in how they're making selection decisions. If everyone being terminated is over 50 and everyone being retained is under 40, that pattern might suggest discriminatory practices that warrant legal investigation before you waive your right to challenge the termination. The company must provide this information in writing as part of the severance package, and your 45-day consideration period doesn't begin until you've received the complete disclosure. Now, there are some red flags that should stop you from signing. Now that you understand your legal protections, let's examine provisions that should trigger serious concern. Elements that suggest the company is either asking for too much in exchange for too little, or including terms that could damage your future employment prospects and financial security. Red flag number 1, overly broad non-compete clauses. Non-compete agreements restrict your ability to work for competitors or start competing businesses for a specified period after your employment ends, typically ranging from 6 months to 2 years. Reasonable non-competes that are narrowly tailored to protect legitimate business interests, preventing you from immediately taking the company's client list to a direct competitor, for example, can be legally enforceable depending on your state's laws. But companies often include non-compete provisions that are absurdly broad, prohibiting you from working anywhere in your industry, anywhere in the country for anyone who could remotely be considered competitive for extended time periods. If you're 55 years old with 30 years of experience in pharmaceutical sales and the non-compete prohibits you from working for any pharmaceutical company anywhere in the United States for 2 years, that provision effectively ends your career. You cannot afford to sign away your ability to earn a living in the only industry where your expertise has value. Before you sign any agreement containing non-compete language, you need an employment attorney to evaluate whether the restrictions are reasonable and enforceable under your state's law, and whether the severance compensation being offered justifies accepting those restrictions on your future employment. Many non-competes are unenforceable because they're drafted too broadly, but you don't want to discover that after you've signed and then have to spend money litigating the issue when a new employer refuses to hire you because of the restriction. Red flag number 2, gag orders about the circumstances of your termination. Some severance agreements include provisions prohibiting you from discussing the reasons for your termination with anyone, not future employers, not colleagues, not even close friends or family members outside of your attorney and spouse. While companies have legitimate interests in preventing former employees from making defamatory statements or disclosing confidential business information, overly broad gag orders can prevent you from explaining legitimate aspects of your departure in ways that protect your professional reputation. If a future employer asks why you left your previous position, you need the ability to provide an honest, professional explanation. An agreement that prohibits any discussion of your termination puts you in an impossible situation. Either violate the agreement by answering the question or refuse to answer and allow the potential employer to draw negative inferences about why you're being secretive. Before accepting gag order provisions, make sure the language includes reasonable exceptions that allow you to provide factual, non-defamatory information to potential employers, to comply with legal obligations if you're subpoenaed or required to testify, and to discuss the matter with your attorney, financial advisors, or immediate family members. Red flag number 3, forfeiture of earned compensation. Some severance agreements include provisions stating that by accepting the severance package, you're forfeiting unvested stock options, unpaid bonuses based on performance you completed before termination, or other forms of deferred compensation you reasonably expected to receive. Companies sometimes characterize these forfeitures as though they're standard consequences of separation. But in many cases, you have legal claims to this compensation, regardless of whether you sign the severance agreement, particularly if the compensation was earned through performance completed during your employment. Before you sign away stock options, bonus payments, or deferred compensation. You need legal analysis of whether those assets already belong to you under your employment contract or the company's compensation plans, and whether the severance package adequately compensates you for what you're giving up. I've seen situations where employees signed away $50,000 or more in unvested options or unpaid bonuses without realizing that the modest severance payment being offered didn't come close to fair value for what they were forfeiting. Red flag number 4, release of claims you didn't know you had. Severance agreements typically require you to release all potential claims against the company, which can include discrimination based on age, race, sex, disability, or other protected characteristics, wrongful termination, retaliation for whistleblowing, or reporting illegal conduct, unpaid wages or overtime, breach of contract, and numerous other potential legal claims. You may not realize you have viable legal claims until you consult with an employment attorney who can review the circumstances of your termination with expertise in employment law. If you were passed over for promotions repeatedly after turning 50, while less qualified younger employees were advanced, that might constitute age discrimination. If you were terminated shortly after reporting safety violations or financial irregularities to management, that might constitute illegal retaliation. If you were consistently paid less than male colleagues in similar positions despite comparable performance, that might constitute sex discrimination. You cannot make an informed decision about whether to waive these claims until you understand whether they exist and what their potential value might be in litigation or settlement negotiations. This is why consulting with an employment attorney before signing is absolutely essential. You need someone with expertise to evaluate whether releasing your claims represents a reasonable exchange for severance being offered. Here's some green flags. These are things that suggest fair terms. Let's examine the provisions that indicate the company is offering reasonable terms that might justify signing the agreement. Green flag number 1, multiple weeks of pay per year of service. The most common formula for severance calculation provides 1 to 2 weeks of continued salary for each year you were employed. Though this can vary significantly by industry, company size, and seniority level. If you worked at the company for 15 years and they're offering 30 weeks of continued pay, roughly 7 months of salary, that represents substantial consideration that might reasonably compensate you for waiving potential claims and accepting restrictive covenants, assuming you don't have strong evidence of discrimination or wrongful termination. If they're offering 2 weeks of pay total, regardless of your length of service, that inadequate compensation should prompt serious negotiation about increasing the amount. Green flag number 2, extended health insurance coverage. Health insurance represents one of the most significant concerns for people over 50 who are facing termination before they reach Medicare eligibility at 65. If the severance package includes several months of continued health insurance with the company paying premiums rather than just providing COBRA notification that requires you to pay the full premium yourself, that represents valuable consideration that extends your runway significantly and reduces the financial pressure to accept the first job offer you receive simply because you desperately need health coverage. Green flag number 3, professional outplacement services. Quality outplacement services providing resume development, interview coaching, job search strategy, and access to professional networks can substantially improve your prospects for successful re-employment, particularly if you've been with one company for many years and haven't conducted a job search in decades. If the severance package includes outplacement support, particularly if it's not the bare minimum 1 month access, but rather 3 to 6 months of comprehensive services, that represents genuine value that could accelerate your transition to new employment. Green flag number 4, written letter of reference. Having a written letter of recommendation from your former employer signed by someone with authority and printed on company letterhead is vastly more valuable than a verbal agreement that HR will provide positive references if contacted. Verbal agreements are difficult to enforce and leave room for interpretation about what positive means. A written letter gives you control over the message and provides documentation you can submit directly to potential employees rather than relying on what HR might say when contacted. Green flag number 5, prorated bonus for partial performance period. If you were terminated mid-year but completed substantial work during the performance period that determines annual bonus eligibility, a fair severance package should include prorated bonus payment reflecting your contribution during the months you worked. If the company refuses to pay any bonus because you weren't employed on the official bonus payment date, even though you worked 10 months of the performance year, that suggests they're not negotiating in good faith, and you should push back on that position. Now let's talk about how to negotiate effectively. The fundamental principle is that everything is negotiable until you sign. The first offer is almost never the final offer. Companies build room into their initial severance proposals, expecting that some employees will negotiate, and they're often willing to increase compensation, reduce restrictive covenants, or modify unfavorable terms if you demonstrate that you understand what you're signing and that you're not accepting the agreement without careful consideration. Here's some things you can negotiate. The severance amount. If the initial offer provides inadequate compensation for your length of service or the circumstances of your termination, you can request additional weeks of pay. Your leverage increases if you have potential legal claims based on discriminatory treatment or if you're waiving particularly valuable rights. Health insurance duration. If they're only offering the minimum COBRA notification period, you can request several months of continued coverage with the company paying premiums, particularly if you're several years away from Medicare eligibility and the cost of individual coverage would create significant financial hardship. Next, let's talk about the non-compete scope and its duration. If the non-compete provisions are overly broad, you can request narrowing the geographical scope, reducing the time period, limiting the restriction to direct competitors rather than any company tangentially related to the industry, or eliminating the non-compete entirely if it's not reasonably necessary to protect legitimate business interests. Job title and separation characterization. How the company characterizes your departure matters for future employment prospects. You can negotiate that they'll describe the separation as mutual or as a position elimination rather than termination for performance. And you can request agreement about what information HR will provide to potential employers who contact them for references. Timing of payments. Sometimes companies want to spread severance payments over many months rather than providing a lump sum. You may prefer receiving the full amount immediately rather than remaining dependent on the company's continued financial health for months into the future. And you can negotiate for lump sum payment as an alternative to installments. What strengthens your negotiating position is this: evidence of discriminatory treatment based on age, race, sex, disability, or other protected characteristics gives you substantial leverage because the company faces potential litigation risk and EEOC complaints if they refuse to negotiate reasonably. Documentation of retaliation for whistleblowing, reporting illegal conduct, or asserting legal rights gives you leverage because retaliation claims can result in significant damages and negative publicity for the company. Long tenure with exemplary performance reviews and sudden termination shortly after turning 50 or shortly after a new manager arrived creates questions about whether legitimate business reasons or discriminatory animus motivated the termination. Evidence that similarly situated younger employees were treated more favorably, they weren't terminated during the reduction in force, they received warnings before termination while you didn't, they were given opportunities to improve performance while you weren't, supports age discrimination claims. Here's how to conduct the negotiation. Do not negotiate verbally during emotional conversations immediately after termination. Everything should be in writing. Emails to HR or to the person who presented the severance offer, clearly stating what provisions you're requesting they modify and why those modifications are reasonable. Frame your request professionally rather than emotionally. For example, you might say, I'm requesting an increase in severance payment from 4 weeks to 12 weeks based on my 15 years of service and the industry standard of 1 week per year served, rather than saying, this is insulting after everything I've done for this company. Set a clear deadline for their response. For example, say, please respond by, say, 1 week from now with your position on these requested modifications. Document everything. Save all emails, record the dates and content of conversations, maintain a file with all correspondence related to the negotiation. If they refuse to negotiate on key terms, that refusal itself can become relevant evidence if you later pursue legal claims, because it suggests they're not bargaining in good faith or that they're concerned about liability exposure. Here's when to walk away. If the severance offer is genuinely insulting, say 2 weeks of pay after 20 years of service, for example, and they refuse to negotiate more reasonable terms, you may be better served by declining to sign and instead consulting with an employment attorney about whether you have viable legal claims worth pursuing. If signing the agreement would eliminate your ability to work in your profession because of overly broad non-compete provisions, and the company refuses to narrow those restrictions, you cannot afford to sign away your livelihood, regardless of how much money they're offering in the short term. If you have strong evidence of discrimination or wrongful termination, the potential value of legal claims may substantially exceed whatever severance payment they're offering, and you should seriously consider rejecting the severance and pursuing litigation instead. Now let's talk about the attorney consultation and why this investment is non-negotiable. I understand that spending $300 to $500 on an attorney consultation feels like a significant expense when you're facing job loss and financial uncertainty, but consider what's at stake. The severance agreement might involve tens of thousands of dollars in compensation, continuation of health benefits worth thousands per month, restrictions on your ability to work that could cost you thousands in lost future earnings, and waiver of legal claims that might be worth 6 figures or more if pursued successfully. An employment attorney can review your severance agreement, assess whether you have potential discrimination or wrongful termination claims that exceed the value of the severance offer, identify provisions that should be negotiated or eliminated, advise you on how to strengthen your negotiating position, and help you understand whether signing represents the best available option or whether you're better served by rejecting the offer and pursuing legal action. That expertise is worth far more than the consultation fee, and the cost of not obtaining that advice could easily exceed $50,000 if you sign away valuable rights without understanding what you're relinquishing. Here's how to find the right attorney. You need someone who specializes in employment law, not a general practice attorney who handles real estate closings and wills. Employment law requires specialized expertise and knowledge in discrimination statutes, wrongful termination, precedents, severance negotiations, and the strategic considerations specific to these cases. Start by asking for referrals from colleagues who've been through similar situations. Search your state bar association's attorney directory, filtering for employment law specialists, or contact organizations like the National Employment Lawyers Association, which maintains directories of attorneys who represent employees rather than employers. Schedule consultations with 2 or 3 attorneys if possible, because you want to find someone whose approach and communication style feels compatible with your needs, not just the first person you contact. Most employment attorneys offer initial consultations at flat fees rather than requiring retainer agreements for full representation. You're purchasing an hour of their time and expertise to review your situation and advise you on next steps, not necessarily committing to hiring them for litigation. Here's what to bring to the consultation: the severance agreement they've given you, along with any other documents related to your termination, your employment contract if you had a written agreement, recent performance reviews, particularly if they document strong performance, any documentation of discriminatory treatment, inappropriate comments, or evidence that similarly situated younger employees were treated differently, your notes about the termination conversation and the circumstances leading up to it, a timeline of relevant events, when you were hired, when you turned 50, when new management arrived, when your reviews changed, when termination occurred. The more organized information you provide, the more efficiently the attorney can assess your situation and give you valuable strategic advice. Here's what you should ask. Do I have viable legal claims based on what you're seeing in my documentation and what I've told you about the circumstances? If so, what's the realistic value range for those claims considering the strength of evidence and the litigation risk involved? Does the severance offer adequately compensate me for waiving those claims, or am I leaving significant value on the table by signing? What specific provisions in the severance agreement should I negotiate, and how should I frame those requests? If I reject the severance and pursue legal action, what would that process look like in terms of timeline, costs, and probable outcomes? These questions will help you make a genuinely informed decision rather than signing in the dark and hoping it works out acceptably. The fundamental principle I need you to remember is that a severance agreement is a transaction, not a gift. You're selling something of value, your legal rights, your ability to challenge the termination, potentially your freedom to work in your profession. And you need to evaluate whether the price they're offering represents fair compensation for what you're surrendering. Too many people over 50 sign these agreements because they're shocked, frightened, and desperate to secure whatever financial support the company is offering before it disappears. They sign without reading carefully, without consulting attorneys, without understanding that they're waiving rights that might be worth substantially more than the modest severance payment being offered. Don't be one of those people. You have legal protections. You have negotiating leverage. You have time to think clearly and make strategic decisions rather than reactive ones. Use those advantages. Take the full 21 or 45 days you're entitled to. Consult with an employment attorney, even if spending money on legal advice feels uncomfortable. Negotiate provisions that don't serve your interests. And if the offer is genuinely inadequate and you have strong legal claims, have the courage to walk away and pursue what you're actually owed rather than accepting whatever they're offering just to avoid conflict. Your future employment prospects, your financial security, and your ability to work in your profession may depend on the decisions you make right now while you're reviewing this severance agreement. Make those decisions strategically with expert guidance rather than signing away your rights because you're too overwhelmed to think clearly. Before you close this video, if you're navigating job loss after 50 and trying to figure out what comes next, not just the severance negotiation, but the bigger questions about whether to pursue reemployment or consider early retirement, how to protect your financial stability, and what gives your life meaning when your professional identity has been disrupted, I've created a comprehensive retirement readiness scorecard that evaluates where you stand across prosperity, purpose, and your capacity for play. That assessment gives you a baseline understanding of your situation so you can make strategic decisions about your next chapter. The link to the scorecard appears in the description below. And if you're dealing with the immediate crisis of job loss and need hour-by-hour guidance for getting through the first terrible day, I've created a detailed Day 1 survival guide that walks you through protecting your assets, understanding your options, and managing the emotional work required to get through this experience without making decisions you'll regret. That video appears on the screen now. You're navigating one of the most difficult professional transitions you'll face. You don't have to do it alone, and you don't have to accept whatever they're offering just because you're scared. Get the advice you need. Negotiate the terms you deserve. Protect the future you've spent decades building. And I'll see you in the next video.